And we are back. Gadfly Radio, CalWatchdog.com. I am Ben Boychuk, sitting in for Martha Montelongo, and Martha and John Seiler are down in San Diego at a conference, so it's just me and you. And joining us in this segment is Avik Roy. He is a senior fellow in health policy at the Manhattan Institute, which is my home base right now. He's also a policy advisor for the Heartland Institute, and he blogs. He's the let me start again. He is the he is the proprietor of the Apothecary blog at Forbes.com, and he's live blogging up a storm at National Review Online because this is a big week in the Supreme Court. The Supreme Court yesterday, today, and tomorrow hearing arguments on Obamacare. The subject of the arguments today was the individual mandate. And so that was we're going to have quite a bit to talk about. Avik, thanks for joining me.
Dan, how are you?
Great. So the question of whether or not the individual mandate is constitutional was the big topic of today's argument. But before we discuss that, we need to talk a little bit about what happened yesterday. And that centered around the somewhat obscure question of whether there can be a lawsuit at all over Obamacare. Can you just kind of give us just a short little synopsis of what happened yesterday and what the question yesterday was all about?
Yeah, so there's an old law from 1867 called the Anti-Injunction Act. And the Anti-Injunction Act says that you can't sue the government for a tax that hasn't yet gone into effect. And the reason for that is that if you could sue and sort of clog up the works every time Congress passed a tax, then the government wouldn't be able to tax anything and wouldn't be able to finance itself. However, the Anti-Injunction Act does not apply to penalties, that financial penalties for when you break the law or violate the law. So the question of whether the mandate is a tax or penalty really matters insofar as if the mandate's a tax, then the suit has to be thrown out because the mandate doesn't go into effect until 2014. On the other hand, if the mandate's a penalty, then the suit can go forward and they can decide on whether the mandate's actually constitutional on its own merits.
Now, I know it's always dangerous to read into the questions and the comments that the justices have when they're doing these arguments, but you wrote about this at Forbes.com yesterday, and you blogged a bit about it at National Review. What was your sense of the outcome of that argument yesterday?
Yeah, I mean, I think most of the newspaper headlines were accurate today in saying that the judges seemed pretty unsympathetic to the argument that it was a tax and not a penalty. In fact, because both the plaintiffs and the defendants agreed that it was a tax and not a penalty, the court had to hire an outside lawyer to defend the other side of the case. So I think that tells you a lot. I asked some legal experts why even bother hearing this if everyone already sort of agreed that it was a penalty and not a tax. And what I was told by them was like, look, there were a couple of lower courts that did rule that it was a tax irresponsibly in my view or incorrectly in my view. But because a couple lower courts did rule that it was a tax and threw out the case on those grounds, the Supreme Court had to consider the question because if they hadn't, a bunch of law professors would hassle them and say that they were acting politically instead of considering the question thoroughly. So they wanted to not leave, cross their T's and dot their I's.
Right. And so today they spent 2 hours talking about whether in fact this individual mandate is constitutional, and that's really the big question. Today was really the big day.
Today was and is the big day. Yes, indeed.
And so you were following along a little bit. Can you give us an idea of kind of how that went today? We're going to be coming up on a break, but maybe give us a kind of an overview, and then we can go on from there.
Yeah. So I mean, I'm still in the process of listening to the arguments.
Sure.
Your show kind of cut me in the middle of that, but the first what's clear is that Verrilli, the Solicitor General who spoke for the government, was very nervous and got shredded by the conservatives, and Kennedy in particular seemed very skeptical of Verrilli's arguments, and that he's obviously the key swing vote here. On the other hand, I've heard conflicting opinions about the other way around. So when the anti-mandate lawyer, Paul Clement, went up to speak, Kennedy also asked him questions, and some people say that Kennedy was kind of equally hard on both sides, and some people say Kennedy was was much harder on the government, the president's side, the federal government side, than on the plaintiff's side. So I want to hear the rest of the arguments to find out for myself. But you do have, I think, most people saying that the odds are, people are feeling much stronger that the odds are that the court throws this down and that Kennedy is going to side against the mandate as of now.
Right. I mean, the argument that the states are making is that the mandate is this unprecedented use of federal power. It's an unprecedented assertion of Congress's power under the Commerce Clause, and it's just something that's never been done. And in the state's brief, in fact, they say if Congress had this power, they would have used it long before now. And so I'm sure that had to have come out. And how did the justices respond to that? I mean, did they have anything to say about that?
Thus far, in what I've read and heard,
Gotcha.
The main thing that they've asked is the question of a limiting principle.
Mm-hmm.
So if Congress can mandate you to buy health insurance, what can't they mandate you to do?
Right.
And a big part of that whole debate is the argument that health care is unique. So the way in which a couple of conservative judges in the lower courts have upheld the mandate is because they've agreed to this idea that health care is unique because we all need it at some point, and therefore the government has the ability to and the authority to regulate that. But the fallacy in that argument, from my standpoint, is health care. We all need health care at some point in our lives, but there are a lot of different ways to consume it. We can choose not to go to the hospital if we're, say, Jehovah's Witnesses. We can go to the hospital but pay in cash for our services, or we can buy insurance. So the idea that just because you don't buy insurance means you're not going to pay for health care isn't accurate, and that's one of the problems with this case that certainly some of the lower courts have touched on and presumably gets touched on at some point during the arguments as well.
Right, and we will. I want to dig into that just a little bit more after the break, and then I want to get kind of a preview of what we can expect at tomorrow's arguments, the third and final day of arguments. We're talking to Avik Roy. He's a senior fellow at the Manhattan Institute, and you are listening to Gadfly Radio. I'm Ben Boychuk. We will be back very, very soon. Do not go away.
You are a